All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Good morning, everyone. We are here for oral argument in 1 CA CV 180268. I'm going to call that Huver versus Huver. These proceedings are being audio and video recorded, so I would ask counsel to please identify yourself and your client at the beginning of your argument. Each side has 20 minutes. Ms. McCullough, you are advised that you're responsible for watching the clock to reserve any portion of that time you may wish to do so for rebuttal. We have read the briefs. We've discussed the case this morning in conference. And Ms. McCullough, you may proceed.
Good morning, Your Honors. Diana McCulloch on behalf of Ronald Huver. Mr. Huver has filed this case for what he believes to be a grave injustice with respect to child support in this matter. In approximately November of 2014, father filed a petition to modify legal decision-making, parenting time, and child support with respect to two children. One of which, and everybody concedes this, the eldest child, Holly Ann, was residing with father since prior thereto. The parties couldn't reach an agreement as to child support at that point in time, and that was in May of 2014. Father waited 6 months before he filed his petition for modification, which was November of 2014.
And mother filed a cross petition. And when was that cross petition filed?
The counter petition was filed the following month.
That would have been December.
December of 2014. Which,
for our purposes, Ms. McCullough, when was the cross petition finally dismissed?
The counter petition was never dismissed.
So the trial court always had jurisdiction. I hate to use that term, but always had the ability, based on that cross petition, to modify legal decision-making, parenting time, or child support. Correct?
That's correct.
From the counter petition.
From the counter petition that was filed in December. At the time, Ms. Stein represented Ms. Huver.
And so then, just to kind of lead you through what I understand this to be, then the parties come together and they resolve the child support issue by filing, was that a Rule 69 agreement, where they would vacate child support until June of 2015, correct?
Correct. What happened is we went for a resolution management conference in late February of 2015. We reached agreements which ended up being orders of the court. There's nothing, it's our position, there's nothing in those agreement or in the court order that says the termination of child support is permanent. There's nothing that says this is a temporary order. There's nothing that says the zero child support order is only in effect until June 2015. It does say, as outlined below, and as outlined below, the only reference to the termination is the court's instruction to terminate the withholding order that was in effect at the time, because it was by automatic wage assignment.
Well, just so from practical purposes, it couldn't have been a final order, because the order, the Rule 60, what I'll call the Rule 69 order, said we're going to revisit child support at a future date, and that would have been of June of 2015, correct?
Well, correct. It said it would be pending June of 2015.
I thought it was more specific. I thought it said it will be revisited or something to that effect.
It said, and I can get you the exact quote. It says, recalculation of child support shall be pending June 1st, 2015.
So the parties were aware when they entered into this order in February of 2015 that there was going to be some modification of the child support order beginning in June of 2015.
Right, and based upon, if you go to the beginning of that order, that was based upon both father's petition and mother's response to respondent's petition and her counter petition thereto, filed on December 23rd, 2014.
So if we accept that her counter petition filed December of 2014 was still pending at that time, and when the court says child support will be pending, whatever you just read, June 15th of 2015, doesn't that say to you that at that point it will be recalculated, and why the June date is so critical is because that's when the oldest child became emancipated?
Correct, and father agrees with that, but it's based upon the petitions that were filed. So it would have been retroactively modified. Father's position is if this was not final orders and that petition was still pending, and which is the argument, is the petition was not pending because of the dismissal of father's petition.
Well, mother's petition, her counter petition was still pending.
Correct. Mother's counter petition was still pending. So the recalculation, of course, would have dated back until the filing of mother's petition, which was still pending.
Doesn't have to be.
Well, it could or it couldn't be. We don't
It's
know.
discretionary with the court. I mean, the court, under the statute, this court can say for good cause, and the good cause in this case would simply be the fact that each parent had a child.
Right.
And the parties agreed to that. That have no child support from February of 2015 through June of 2015.
No, there would have been, if the court
That's
would
what
have.
the parties agreed to.
The parties agreed that father's wage assignment had to stop, and therefore the child support was terminated in March, because what had happened is between June and his filing of his petition and the filing of his petition until February of 2015, father was paying for both children's support because the oldest child was living with mother until June, the end of May, beginning of June of 2014. So father's petition addressed child support as of the date of filing pursuant to the statute, as did mother's counter petition. Said the court at best needs to go back and modify in her petition. She states clearly you have to go back and modify child support back to December of 2014 at $163. I'm paraphrasing here. So, but in the meantime, father was paying $1,000 a month. So from December, January, February, March, father paid $1,000 a month, when even mother conceded he was only supposed to be paying $163, and she paid no child support for Holly Ann. So the oldest child got no child support from mother. Father paid for both children for child support from the date of filing his petition, at which date, in which mother responded, yes, I acknowledge that father's not supposed to be paying this much child support. He has one child. And so from that point forward, father was paying until this agreement the $1,000 a month, when mother said he was only supposed to be paying $163. So he was overpaying for at least those 4 or 5 months.
The order itself didn't discuss or didn't contemplate any retroactivity of the order, correct? I mean, the order just said we're going to vacate child support, and it will redetermine or recalculate child support in June.
Yes.
So there was no discussion about whether or not there would be some type of credit or some type of dating back to November of 2014.
Well, there was, but there's nothing on the record. I mean, I was there, so I know what the discussion was, and
But I don't know that because I don't have the transcripts, right? You didn't order
correct.
the
I don't
transcript.
think it would be on any transcript. It was a discussion we had discussions between counsel and our clients.
So we're talking about discussions between counsel and your client. You were saying that the court erred in not awarding father retroactive child support between November and February. Is that what you just said?
The court erred in not going back to the date the petition was filed. If the court was going to modify,
But in essence, the court did not modify your client, and your client entered into an agreement. So shouldn't that agreement have contemplated that and included that in the language of the agreement at that time?
no, because we weren't in agreement as to what anybody's income was. So we couldn't come up.
One of those does not equal the other. So let's just take this one at a time. Your client goes to a settlement conference of some variety or enters into a settlement agreement that says, from February of 2015, neither of us are going to pay child support because you've got a kid and I've got a kid. And that agreement says until June 15th, this agreement holds, but at that point, child support issues will be pending before the court or live before the court again. But you don't address any of the retroactive kinds of issues in that agreement. Why would we give him credit?
Because that's what the statute contemplates.
Sure, it contemplates it, but when you enter into an agreement, you include all of the information and start from that point in time and move forward. Would you agree? That's why we have agreements.
Well, right, and the parties couldn't come to an agreement with respect to what date anything started. Father actually wanted the child support to go back to June of 2014.
Which we all agree is not entitled to.
Right.
Under the statute.
Yes.
Okay, so we've got the statute, we've got this agreement, then we've got a dismissal of his petition.
Correct.
Why was that not argued at the point in time the court dismissed his petition?
Why was what not argued?
The retroactive child support. If that was still at issue, why wasn't that brought up in the trial court?
I don't know that it wasn't. In the dismissal documents, we all argued everything. I mean, it got dismissed. Mother asked to have the petition dismissed. Father's petition, the court, after briefing, dismissed father's petition without prejudice. Of course, father's refiling that petition would have dated from the date under the statute that he refiled. Mother then...
Did father's petition raise different issues than the counter petition did?
Did father what?
Did the father's petition raise different issues than mother did in her counter petition?
Yes.
Or was it all the same issue?
They were the same issues. They didn't agree on what would be the termination date or what would be the date that everything would be modified. And because of that, that's why we did 0. We agreed on terminating it because we couldn't come to an agreement, and a resolution management conference is just those matters that you agree upon. And so the matters that we could agree upon was, certainly this child support has to stop. Father's paying $1,000 a month and fully supporting Holly Ann, who has no parenting time with mother. So father's 100% responsible for Holly Ann, and he's paying $1,000 a month child support because it takes this long to get in for a temporary orders hearing, which we hadn't even had yet. So by the time we went to the settlement conference or the resolution management conference, we just did what we could to stop the bleeding. And to stop the bleeding...
In February of 2015.
Correct.
And then let's fast forward to January of 2018 is when you had your you had an evidentiary hearing on this issue, correct?
No.
All right.
Okay. What happened was, father's petition was dismissed.
And
By the court.
let me rephrase the question. You had a hearing in January of 2018.
Yes.
January 17th of 2018, if my notes are correct.
Yes. That was on mother's...
Basically a contempt petition for failing to pay, correct?
Right. Mother never pursued her counter petition.
Okay, well, but let's back up. So at this hearing, you raised, or it's alleged you raised all of the arguments that you're raising here today about whether or not it should have started at the date of the that was part of your defense to the petition, the contempt petition, correct?
Correct.
All right. So the trial court made a ruling, correct?
Correct.
And at that hearing, we don't have the transcripts from that hearing.
Okay.
And I thought the presumption, or correct me if I'm wrong, but I thought the presumption is if you don't provide us with the transcripts, we presume that what the trial court did was correct. So all of the issues that you've discussed here today about whether or not this temporary order that was issued in February, whether or not that was a valid determination of the Rule 69 agreement to issue that temporary order back in February of 2015. And I have no way of reviewing what the trial court said or didn't say and why she did what she did, do I?
No, but you can read it in the minute entry by Judge Record. If we go to Judge Record's minute entry, she clearly states father wasn't in contempt. The parties agreed to a termination. Father's not in contempt. The basis for her modification was fairness. Was father had an obligation to support the younger child, but then totally disregarded with respect to the older child. So if we're going to base it not on statute, she did not base the modification of child support from the period of what she ordered, June 1st of 2015. Mother did not plead for that. We went on a petition for mother's petition for contempt and modification as of the date of filing of that petition, not her prior petition.
But her prior petition was still pending, so can't we, as the court, with no transcript to figure out what went on at that hearing, use the operative pleading as the counter petition filed December 20th or December of 2014 and find that the court was justified in what it did? That's what I'm not figuring out.
No, because then father didn't have notice of that.
How did he not have notice? He got a copy of the petition.
Right. But they filed another petition, and the court set the matter on that petition only. The court did not set the
But you entered, or you had in your exhibit list, evidence from mother's tax returns clear back through 15 and 16. So how are you prejudiced? I mean, it's one thing to say, oh, I didn't have notice, but what's lacking? You had her tax return, his tax return, her tax returns. So what could you have presented otherwise?
A plethora of evidence of things outside of her tax returns. There was a tremendous amount of discovery done, into her income. Mother's not self-employed, but she's employed by her mother. So, and there's houses that they own, and it's a complicated financial scenario. Father was willing to go forth with knowing he wasn't in contempt and was willing to, and agreed that he owed child support. Father, till this day, does not dispute that portion of the order. He says, you filed a petition in November, I believe, of 2016. I don't object to that. I don't object what happened from 2016 when you filed your petition and you gave me notice. And we were fully prepared to present evidence as to mother's financial circumstances as of that time. That isn't what the court did. The court went back, and because they modified, not based on mother's new petition, not considering the counter petition that had been filed back in 2014, the court used a 2011 worksheet. That's what they used to determine what child support even should have been, because there wasn't sufficient evidence to present, because neither party had notice of that. I
think your position would be more well suited, or if that's even correct English, if you had presided us with the transcripts. But I don't have any transcripts that are explaining to me why Judge Reckert used particular evidence versus others, or why she. And so I have no way of saying, oh yes, she made a mistake.
I think that actually in her minute entry, it clearly indicates that she found that father owed the child support based simply upon fairness. And if she takes the liberty to do such, then I think that she needs to take the liberty to then do the same with respect to the other child. And I think that that's clear in her minute entry. There is no support, no legal support, other than the quote to the court needs to do what's fair and equitable. And so her minute entry, I think, speaks for itself. It clearly states I have no statutory basis for this, but I'm making a modification anyway based upon fairness, without then doing fairness to the other child.
Anything else? Your time is just about expired.
I know. And I think that that's something that the court needs to seriously consider. If we're going to completely ignore the statutes and we're going to just proceed, nobody has notice of anything. We just go in and it's everybody's fair game, and we can't present a proper case. There's no way in 2 hours we could have even presented evidence going back to 2014, 2015. Especially in this case.
All right, thank you.
Thank you.
Mr. Zarzynski.
Good morning, Your Honors.
Good morning.
I'm John Zarzynski. I'm appearing on behalf of Addie Huver, who's not present today. Not a particularly, it was a long case, but it wasn't particularly difficult procedurally. Original divorce, as you know, was back in May of 2011. Parties had 2 minor kids at that time. Dad had a non-divisible child support order for those 2 kids at $1,000 a month. Nothing really happened then until father filed his petition to modify the parenting time, legal decision-making authority, and child support, and he did that in November of 2014. As the court has noted, Maria Stein, on behalf of Addie, filed a response and counter petition to that petition filed by father, indicating that she wanted to keep primary care of the youngest child, modify child support as appropriate. Parties, as is the norm, went to an RMC, or Resolution Management Conference, in late February of 2015. At that time, they put on the record a Rule 69 agreement, and that agreement basically said that commencing in March and pending recalculation in June of 15, because each party had a child, that neither would pay support to the other. I mean, it's pretty simple. Everybody recognized, as Judge Campbell pointed out, that the oldest child, Holly, was emancipating. She'd already been turned 18, I think, in January of that year, but she was graduating from high school in June, or at the end of May of 15. So that was the emancipating event. At that point, there's only 1 child left in mom's primary care, and we'd have to figure out what the appropriate child support was for that.
Was there anything in the Rule 69 agreement about the months from November until February?
No. And that was the time to bring it up. If they wanted to say that, there's that issue, we'll agree to this period of time, but we won't agree to November to that's the time to bring it up. They didn't. It's just not part of the record. So we have a clear Rule 69 agreement. It's on its face. It's easy to read and understandable. And it comports with exactly what these parties knew to be the case. Holly Ann was going to emancipate at the end of May, and so starting June 1st, we only have 1 child to support. That child's going to be in mom's care at least until that father's petition, and he was asking for primary care of the youngest child too, at least until that was resolved. So that continued on for a year, frankly, from February of 15 until February of 16. Lots of stuff was happening in between, as the record indicates. But essentially, what happened in February of 16, pardon me, is father came to the court and said, I know I filed these motions to do a full custody evaluation. I know I filed these motions for another counselor other than the child's current counselor. I don't have the money to do that. So at that point, by Judge Record's orders in February of 16, she said, okay, I'll rescind your stipulation, and I'm going to put this case on the inactive calendar. Dad, marshal your resources. It's actually right in the minute entry. She's going to give him time to come up with the resources to pay for these professionals that he had been asking for. But I'm going to put this on the inactive calendar for dismissal unless something happens. Well, nothing did happen. So in July of 2016, what was that, 4 months later, I think 3 months later, she simply dismissed father's petition.
And prior to July of 2016, we assumed that all parties received notice it was going to be dismissed.
Oh, absolutely.
And nobody filed anything to keep his petition on at that point in time.
In fact, that was the invitation in the February of 16 minute entry, which placed it on the inactive calendar. It invited father, tell me have you marshaled your resources and, in essence, to pay for these professionals so we can continue on with this petition. Just never happened.
Was it just oversight that your client's counter petition wasn't dismissed as well?
Yeah, I think so. I think it's probably just oversight.
But it's still pending.
It's technically still pending, absolutely. Now, just to be, at that point, if what I was worried about is, if there's nothing pending and dad is now gone from June of 15, the emancipation of Holly, and has paid no child support for Sailor from June of 15 till 17. That's too long. We need to get something. So I did file the petition to enforce the other order and to modify the support. I did the enforcement simply because if, in fact, we could...
When you say enforce the order, are you referring to the 69? The
No,
Rule 69 agreement?
No, I was actually referring to the original decree, because if, in fact, everything had been dismissed once father's petition, including the counter petition, the only operative order left was the original decree, the non-divisible child support order of $1,000 a month. And that's what my petition basically said is... Well,
that depends on whether we view the Rule 69 agreement as a temporary order or as a permanent order.
That's right.
Isn't it?
That's right. And my argument at the time, and again, I think it's 6 of one, half a dozen of the other, frankly. My argument at the time was, it's a temporary order done at an RMC during the pendency of these competing petitions that at least the father's was ultimately dismissed.
Well, except just because it's an RMC doesn't mean it's a temporary order. It still could be a permanent order.
Well,
yeah. Parties get together and decide permanent orders all the time.
Sure. I mean, and that's just a matter of interpreting the order, whether or not we viewed the I think it was a permanent order as it related to the waiver of support by either party from March to June. Mother never saw it, even in her other petition.
But the order itself clearly indicates that you're going to have to recalculate child support in June.
Everybody had notice of that. Everybody knew that was going to happen. And all I wanted to do in case it was overlooked was to make sure I had a pending petition not only to enforce but to modify so we could wrap things up and get support started that had gone, I think, by the time we got to trial, almost 2 years. This child had received $0 in support. So the court found everybody knew that there was going to be a recalculation in June. The court did it. Now, my argument was it should have been $1,000 a month and that Dad got a windfall, but either way, she calculated it. How do we know she didn't follow whatever evidence was presented at the time of the hearing? Because we don't have a transcript, as you were pointing out.
When you look at the minute entry that came out of that evidentiary hearing, we have Ms. McCullough arguing it was based on fairness, not on the statute. Is that how you read that order?
No.
Explain how you read it differently.
Okay. I believe the judge found that the agreement that was reached in February of 15 to recalculate child support as of June of 15 meant just that there was an ongoing support obligation that everybody was aware of that had to be recalculated, and she did. So I don't see how that doesn't follow the statute, frankly.
And when we talk about notice of that hearing, Ms. McCullough argues that it was simply on your enforcement motion. It wasn't on the counter petition, which you concede you think it was an oversight that it wasn't dismissed. Is that correct?
I think so.
So do you think the court should have only calculated back support from the date of filing your motion to enforce and your new modification petition?
Well, no. I think it depends on how the court viewed that Rule 69 agreement. If they viewed it as a temporary order that was dismissed when father's petition was dismissed and included mother's petition being dismissed, which she couldn't have found, because if she would have found that was a temporary order that was dismissed when the underlying petitions were dismissed, she would have had to have enforced the original order of $1,000 a month. So she clearly felt that the counter petition, she must have concluded that the counter petition was still alive, because she went back and found that it had to be modified as of June of 15, as everyone originally contemplated.
And not only could she have found that the counter petition was still viable, but she just treated your motion as a motion to amend the counter petition.
Exactly. And everybody was aware of what we had to fight about. I mean, sure, would I like to have gotten arrearages at $1,000 a month going all the way back? Sure. But did the judge do the right thing? Absolutely, she did the right thing. And she followed the evidence that was in front of her, not only for the back support, but for the support starting again in November of 17, I guess, or 16. I can't remember what date it was when I filed my other petition, so to modify. So that's essentially what our position is, Judge, that the judge followed the law with specificity and did the right thing.
Any additional questions?
Thanks, sir.
Thank you. The matter is deemed submitted. Thank you very much for your arguments here today. I will take the matter under advisement. We are now going to prepare for our second case. We're a little bit early, but hopefully everybody's here. Thank you.
Thank you.